I've called this area of the presentation the Reelection Publications. Prosecutor Cooper had to run for re-election in 2012, and she's not talking to me, but the word gets out. I would like her to explain to me why she talks to the media and doesn't talk to me. And the first instance was in June of 2012. Channel 4 went public with some information about the Bush case. And in November, as I told you, I sent a FOIA request to Prosecutor Cooper, and I said, please give me the FOIA request you got from Channel 4 and anything you gave Channel 4 in response to that. And the FOIA request was kind of interesting. It was dated June 18, 2012, and what Mr. Dietz asked for was the documents you showed me yesterday. He didn't identify them. And those documents were as follows. They were the prosecutor's criminal file in the Bush case, from the complaint through the papers indicating conviction and probation. It was the preliminary examination of the witnesses prior to trial to find out if they had good cause to charge him. And there was a 3-page affidavit that the prosecutor got from somebody who did some testing on the ropes found in Christopher Bush's bedroom. Now, this was the information that I asked for in my initial request to the prosecutor in May 2012 when I started suit. May 2010. And then Mr. Walton made arrangements to meet with Lisa and Chris and me on June the 25th about that release of information. He spent about 2 hours explaining to us an interesting addition to the file that was not normal. On the prosecutor's file of the complaint, that's how what you tell people they're being charged with, it said, no deals, R. Thompson. And he explained to us that meant the assistant prosecutor who was handling the case could not settle the case without the approval of Mr. Thompson. And there was nothing in the file indicating that when Bush went to trial and pled guilty and got probation, that anybody had gotten approval from Mr. Thompson. And Mr. Thompson, that Walton said Mr. Thompson told him he didn't remember anything about it. That's, again, the most heinous crime in the state of Michigan. And he had driven to Flint. One of the reports said it flew up in a helicopter. But in a major snowstorm and attended the polygraph examination of Mr. Bush. The prosecutor who took the case to trial was Leonard Gilman. He was subsequently appointed the U.S. Attorney in Detroit and has died. But the case got solved, or got closed without following normal procedures in the prosecutor's office. Walton even indicated if that happened today in that office, that attorney who appeared at trial would be fired. Another interesting part of the file, which Mr. Walton did not discuss with us, which we found out after we reviewed it, was there was testimony from the victim here in Oakland County was Kenneth Bowman, and they had testimony at the preliminary examination of his mother. And she said the day that the offense took place, he left the house in a Pontiac automobile. Remember, Pontiac, not Blue Gremlin, with Mr. Bush, Mr. Gunnels, Brent Bush, the nephew, and Vince Gunnels. Now, you'll recall Mr. Gunnels told Chris and I that he was only with Mr. Bush twice, the 2 times he got abused up north. To me, that means there was some established social relationship between Mr. Gunnels, Mr. Green, and Mr. Bush when Kenneth Bowman, the victim in Oakland County, was abused. And during that meeting, I also had an opportunity to ask Mr. Walton who was it that called me a felon and told Mr. Dietz about the grand jury, and his answer to me was Mr. Dietz. Of course, that directly contradicts the letter Mr. Dietz gave to the prosecutors saying Barry King was not the source of my material and I will talk to it under oath, and supports my conclusion that the only reason I was hauled into court that day was based on suspicion and coincidence and innuendo, all the things that no prosecutor should ever take anybody into court for and ask the questions. As Ms. Cooper has said many times to the public, it's not her job to do the investigation, it's the job of the police. So, and when you follow this June release of information to Channel 4, most of my responses that I've given to you all were found out after I got the response from my FOIA request. And it's an election year. Why won't Mr. Dietz or the prosecutor's office tell me why they got together on June 17th and shared these documents, but they didn't want to release them until they got a FOIA request? I guess they want you to go in the front door, not the back door, but it depends on who's talking. Then in October, the Detroit Free Press filed 2 extensive articles on the Bush involvement by David Ashenfelder, a Pulitzer Prize-winning reporter, who initially got my memorandum when he appeared at one of the Bob conferences. And I think in accordance with the normal procedures, in fact, it seems to happen every time that I go public, whoever I talk to in the media goes out to the prosecutor's office and says, "What's your reaction to Mr. King?" And I think that's proper. You're supposed to check all the sources when you run a story. You can't just go public saying that Mr. Wasser's released without talking to Mr. Coffey, but again, that depends on who's talking. And I sent a FOIA request saying, please give me the Free Press FOIA requests and what you gave the Free Press. Well, the initial FOIA request to the Free Press is dated October 5, and says, please give us your files on the Oakland County child killer case. Well, there's a room filled up with at least 10 by 10 and probably bigger, full of file cabinets, and there was no response to that, but there's another undated FOIA request, an email request, from Lori Brazier, the reporter at the Free Press, asking for 4 things. She wanted all documents provided to the family of Timothy King. Well, that'd be pretty simple to answer because I told you how many I've gotten from the prosecutor. They wanted the Birmingham Police Department reports on the investigation. They wanted the documents related to the vehicles the police investigated, including the Blue Gremlin. And they wanted the autopsy reports on the bodies of all 4 of the children. While they were assembling that information, the Free Press published the Ashenfelter article. And they then, a couple of days later, provided another article from Miss Brashear covering some aspects that were not in Mr. Ashenfelter's reports. Now, remember, when Mr. Ashenfelter went public, he went out to the prosecutor and said, what's your story? When Miss Brashear gets this report from the prosecutor, she doesn't come to Barry King and say, what's your reaction? But it was public information that they were concerned because of the 2-gender relationship in the 4 victims. We've discussed that in this presentation. And they discussed the trace evidence fact that maybe these murders weren't done by the same people. And this is election year. This is October, a month before the election. The month when Barry King went public in an ad for her opponent, Mike Bishop, saying essentially, she won't talk to me. And none of the information that she provided to the Free Press was given to me. Yet on February 13th this year, 2013, the Oakland County prosecutor went before the Michigan Court of Appeals and continued to argue that Barry King wasn't entitled to any information on this case. Not even the information that I'm giving to Channel 4, not even the information I'm giving to the Free Press. Bewildering. The Constitution doesn't say the media has access to the reports. The Constitution says crime victims have a constitutional right to confer with the prosecutor. And at the same time, a month or two before the election, I talked with Marnie Keenan, and she said she had a 2-hour interview with Jessica Cooper on the Oakland County child killer case. Well, I'm aware of the responsibility that the media have to protect their sources, and I haven't talked to her at length about that. But she takes 2 hours to talk to Marnie Keenan and none to talk to me. Marnie also said she was not very flattering to me and referred to me as an 81-year-old senile attorney. And that's no longer true because now I'm 82. And probably the worst offense she committed prior to the election was October 26, 2012, when she got on TV and said, "I met with Barry King 27 times," and waved this paper. Well, not this paper, but one similar to it. So in my FOIA request in November, I asked her for the 27 meetings that we had, and she sent me the list. And I've prepared a response to that, which I've made public. 19 of them referred to court hearings or court filings by her office. Now, a court appearance and court filings are not meetings. In fact, the only time the prosecutor ever talked to me socially on all of those occasions was the time when Mr. Walton asked me if I knew who Bob was. Even getting them to say good morning to me seemed to be a chore. So that's 19 of the 27 meetings. I leave it to your own good judgment as to whether that's a meeting. So that leaves 8 meetings for us to discuss. The first one that she lists is the October 27, 2009 task force meeting. And I did meet Miss Cooper that day. We shook hands, exchanged some social pleasantries, and the task force answered none of my questions. I've repeated that several times. Is that a meeting? Well, by her standards, it is. The next was a letter she wrote me on November 13, 2009, after the meeting. I don't consider a letter a meeting, but by her standards, it is. Then there are 2 references to my phone calls and the meeting on February 25th with the task force, February 26th, with the task force to discuss the status of the investigation. I called 4 times, twice to voicemail, twice to operators, asked her to talk to me. I got no response. On the last phone call, I said, "Miss Cooper, would you please acknowledge that you're getting the calls?" I would, just for my own files. She had Chief Don Stutt call me and say that I could not attend the meeting. She counts that as a meeting. I leave it to your own good judgment. The next one is May 14th, 2010, when I filed my first FOIA lawsuit. Filing a lawsuit's a meeting? Not in my judgment. Then she refers, and she doesn't put any date on this, she just says the spring of 2011, that she called my attorney, Dave Binkley, and asked him to come out and meet with her. My attorney in the Oakland County prosecutor's case is Lisa Milton. It's not Dave Binkley, but Dave is a friend of hers and a member of my law firm and has represented me in the Michigan State Police case. I told Dave I would like to accompany him. He was told not to bring me. He got back and told me that they wanted me to lay off. And I told him that that wasn't going to work, and I told him not to accept any more invitations from his friend Jessica Cooper unless I could attend. So a meeting with Mr. Binkley is a meeting with me. Your own good judgment. Next is the June 25th, 2012 meeting where we sat down with Mr. Walton and talked about the information that they released to Channel 4. Maybe she had a guilty conscience, but her office did meet with us on that date and share with us that information. I've brought that to your attention elsewhere in this presentation. Mr. Walton also told me at that meeting that Mr. Dietz had told him that I was the source of the information on the Oakland County grand jury. Frankly, when we left the meeting, Lisa, Chris, and I thought it was almost an attempt to badmouth Brooks Patterson and his staff back in 1977, more so than an information to meet with me. The next occasion is August 29th, 2012, and she enters that one twice. Now, that's the meeting I had with Sheriff Lieutenant Gary Miller. I arranged that meeting through a letter or note to Sheriff Bouchard. I did not go through her office. I don't know what her participation was in it. But if my letters to Mike Bouchard are meetings, I guess, again, it's a meeting. Now, I leave it to your own good judgment as to whether there were 27 meetings with me or whether she deserves an Academy Award for her presentation of Senator Joe McCarthy when he appeared before the Senate and said, I have a list of all the communists in the movie industry. More striking than all of this is two occasions when I did meet with her that she didn't include. On July the 20th, 2011, she asked me to come to court, sat down with me in Judge Martha Anderson's chambers, accused me of felony because I told Kevin Dietz about the existence of the Oakland County grand jury, an absolute falsehood upon which he has given me no facts to support that allegation. I don't blame her for omitting that one. I wouldn't want it to come to the public's attention either. And the other one is the following day when I appear before the Oakland County grand jury and meet with her outside in a conference room and try to have her explain some things to me. She was just insulted that I wanted to know about her relationship with Jane Burgess, the attorney for Christopher Bush. And the reason I wanted to know about that relationship is Judy Diebold, my friend at the Detroit News, when she found out Jane Burgess was involved, said, well, before I got married, I used to run with those girls. I would have drinks quite often with Jessica and Jane Burgess. And is it possible? I don't know until somebody talks to me. Is it possible that Jane Burgess and Jessica Cooper talked about the Christopher Bush involvement back in '77? I talk about my existing cases with my friends in the business often. You like to know what their reaction is to your position on it. that's when she told me that Kim Worthy wanted to be governor, and that's why there were 2 grand juries. And then she kind of left a little early because I think she realized that we were in an area she didn't really and shouldn't be talking about. I met with Mr. King 27 times. Michigan Rules of Professional Conduct 4.1 say you cannot tell the public something that's not correct, that might affect the outcome of the case. I've been telling all these judges in the courtrooms that she doesn't meet with me. She goes on TV, and if these judges watch that program, she's saying, he met with me, I met with him 27 times. She's calling Barry King a liar. And I have filed a professional grievance report with my grievance commission for attorneys, indicating that she violated Rule 4.1 when she went public with this information. I certainly hope they examine it and determine whether that's true or not, because no prosecutor in any case should be allowed to go into a courtroom and say that the other side is full of beans.